Now, we'll try and stick relatively closely to the timetable, but what we had proposed was this. Arising out of Jim's talk, there are a number of issues which really probably need a little bit of further discussion. But so what we propose is for each of Tim, Angus and Jim to speak very briefly about a couple of matters, and if there's questions as we go along, or if any of us want to interrupt each other while the other's talking, we'll feel free to do so, and you should feel free to ask any questions. Jim has given the legal overview, so I'd now ask Tim to make a few brief comments on the relief and procedural matters rather than the substantive legal matters. So Tim, if you could.
Thanks, Eugene. Procedure in these applications is interesting because it seems that Parliament's pretty good at giving us lots of procedures. It cannot be said that applications under the Fair Work Act are straightforward, and what this legislation lacks in evidentiary requirements, I think it makes up for with procedural elements. And I'm going to speak about three things, some of which Jim has touched on already. First one, those practising in this area would be familiar with the requirement of a certificate in a termination-based general protections proceeding, and would be familiar with the two-part structure that comes with most discrimination-type applications, where there is a conciliation or mediation phase, now called a conference, and then the more substantive hearing. Now, in an unfair dismissal, of course, that substantive hearing occurs in the tribunal, and in a general protections application, it takes place in one of the two federal courts that's been mentioned earlier. The adverse action regime differs from other types of termination applications in several respects, and one of those is based upon the certificate. Now, pre-Fair Work Act, the Workplace Relations Act, focused in a couple of respects upon the requirement for a certificate, and this legislation is no different. What is different is that there are separate streams, if you like, of certificates. Some under Part 6.4, which deals with unlawful terminations, and general protections under Section 369. Now, my own practice has focused a little bit. It's on, it just doesn't bloody work. My own practice focuses on some of these procedural aspects because I've run applications dealing with those certificates and dealing with the consequences of them. And one case that I dealt with, is it working? Yeah, beauty. One aspect that I dealt with is the overlap between the multiplicity sections, 723 and 725, and the certificate. So in short, the requirement to have a certificate means that there is no cross-pollination or crossover between different types of termination application. You can't, for example, issue an unfair dismissal and then have that heard or determined as a different type of application. And the constitutional and regulatory limits between the previous legislation and the present legislation mean that an application under 723 is barred to applicants who might wish to rely upon unlawful termination grounds, the former 170CK and 659 sections. Basically, the legislation gives precedence to the general protections regime. Those of you who had a look at the Fair Work Act when it was being developed might have noticed that the Fair Work Bill, in its first form, didn't actually contain unlawful termination provisions, but it contained adverse action provisions in similar form to the way it is now. So attention to the certificate, I think, is one of those trip-up areas where practitioners who don't practice in this area regularly might not be aware of some of the traps there. One of the cases I refer you to is Beggs versus Login Systems. It's a recent decision that I was involved in, and it identifies some of those problems in detail. It was a decision of a judge of the Federal Circuit Court, Heather Riley, some 6 weeks ago. Jim referred to the time for application. That's the second port of call for the procedural elements I wanted to talk about. For no reason I can adequately explain, Parliament decided to shorten the period in which general protection applications can be made from 60 days to 21 under the 2012 Fair Work Amendment Act. It means that previously general protections was a kind of a catch-all. If you'd missed the time limit, which used to be 14 days for unfairs, some applicants would bring a general protections claim as their kind of last resort. Clearly, that's not going to feature as strongly in the future because the time limits for those involving dismissal are identical. The 60-day rule used to mean there was a lot more latitude for parties to get their act together and even to discuss before issuing. That also seems like unfair dismissals to have gone by the by. There is, as previous legislation has, also a prohibition on multiple proceedings. The prohibition in this legislation on multiple proceedings, though, is different than others. It is a confused section that exists at 725. The definitions and the use of definitions between court applications and applications issued at the tribunal stage is not clear, and it's probably awaiting clarification by someone with the daring do to issue a couple of applications and see exactly which of those survives a strikeout application. My view is that the previous law, which used to exist as a prohibition on multiple proceedings, is of probably little or no use when considering those procedural elements. And one of the cases on this is a case by a member of our bar, Tim Jacobs, Adam versus Apple. It's a decision of Whelan, Dominica Whelan, a former member of the tribunal and now a federal circuit court judge. Now, those three aspects of procedure I've just touched on are a bit of an overview because there are many other places for applicants to trip up. But not all of them result as Beggs and Login systems did in a strikeout. Some of them are amenable to change. The arguments made in Beggs versus Login was that an error in the certificate deprived the applicant of the power to cure the proceeding and he had to go back and start again in the tribunal. And that's something that I think is a warning to those considering issuing these applications. Now, I probably should have started with relief first because what relief an applicant can get is usually the first consideration when someone comes to ask you about one of these things. But I'm only going to talk about two aspects of the relief, and they are penalty and reinstatement. Because the general protections are a penalty proceeding, that leads to certain consequences. One of the consequences of which is invoking Section 140 of the Evidence Act. Penalty means that it's quasi-criminal in nature. Means also that there's established authority that means that the applicant has to get his or her case pretty clear and pretty right if there is to be a pleading, because otherwise there is a presumption that the respondent won't know the case that the respondent is to face. And the penalties are substantial. In late 2012, they went up from $110 per penalty unit to $170. That means for corporate respondents, they went from facing a $33,000 per breach possible penalty to $51,000. And that's the first time, I think, in about 15 years that penalties have increased, and they increased by a substantial amount. During the break, Angus and I were talking about reinstatement because reinstatement in an unfair dismissal regime makes or breaks a case. It's either on the one side of the line, it is a reinstatement application, or it's on the other side of the line and it's a compensation case. The same equivalent rationale doesn't really exist in general protections. You struggle to find a general protections case that has really thoroughly looked through the question of reinstatement. But reinstatement seems to be a complete deal breaker for many employers. That is to say, one of the reasons I suspect that Barclay ran is it was a reinstatement case, both the first instance and in the intermediate appeal. The way that I read the relief sections in section 539 to 546 is that reinstatement will be a focus of the federal courts where it's sought, obviously. No court will impose reinstatement on parties not seeking it, but where it meets the compensation requirements of the Act. That is to say, where other types of relief would not be or could not be adequate compensation. I was in a termination proceeding earlier last week where the applicant lived in northern Tasmania, an area that has quite high unemployment. He was over 50 years of age, and it was argued, I think, reasonably forcefully for him that reinstatement was really the only relief sought, because in the area in which he lived and the age that he had, he would have faced severe difficulties finding not only comparable alternative employment, but any alternative employment at all. So those are some procedural and relief things to think about. I'm going to hand over now to Angus, but if there are any questions, please ask them. I'm reasonably sanguine about answering off the cuff. Judges do it without asking, so you should take your opportunities where they are.
I actually didn't think that being over 50 was all that bad until Tim decided to describe that case about the impossibility of reinstatement in particular areas.
Work anytime soon, Eugene.
All right. One of the things that's been revealed by Tim and Jim's talk is that there is a range of causes of action and places that applicants can go to seeking relief, but quite often, because of the pretty short time limit, 21 days, these decisions have to be made pretty quickly. So now I'd like Angus to raise a couple of issues for you to think about in determining where to go, what relief to seek and in what tribunal or court.
Thanks, Eugene. Yes, obviously one of the things that immediately arises when particularly an employee applicant comes to see you is what type of claim are we going to bring? Are we going to do general protections, which has been the main focus of today, or perhaps unfair dismissal, as Tim mentioned briefly, or discrimination proceedings under federal or state legislation? They're sort of three of the main ones that often need to be considered. As the name suggests, with unfair dismissal, the employee has to have been dismissed. The definition's in section 386 of the Act, and obviously if there hasn't been a dismissal, an employer will bring a jurisdictional objection and you may not get very far if you can't establish that. With your discrimination claims or your general protections claims, obviously the adverse action that you're complaining about can extend beyond having simply been dismissed, and it can include injury, the alteration of entitlements and things like that. So it's certainly broader in its application in that sense. There's also, I suppose, some legal substantive considerations between the three that are relevant as well. In the paper, Jim's touched on this reverse onus that exists in general protections claims. And that's something that, and the policy reasons for it are discussed as well, and that's something that can benefit an applicant and make proving aspects of the case or establishing the elements of your causes of action simpler when compared to, say, a discrimination claim where a lot of the federal legislation puts the onus onto applicants and requires this, what some of you might have heard about, these comparator tests about you have to identify a person or a hypothetical person who wouldn't have been treated the way the applicant with the particular attribute was treated. And those federal discrimination legislation apply in employment situations. That's one of the areas where that's covered. But also another difficulty with those is that there are exemptions that employers can rely on to defeat the claims. Charitable organisations is one that is in a few of the different acts that comes up. Time limits has been talked about a little bit by my friends up here. The time limits have changed, as Tim said. It's 21 days now for dismissals after the 1st of January 2013 for general protections and unfair dismissal. It is difficult to get extensions of time. Representative error is one thing that can amount to exceptional circumstances, so I don't meet too many solicitors that are willing to sign up to a witness statement saying that it's their fault that everything's fallen apart, but it can, or counsel in that case. But with discrimination claims, it's interesting. Both the federal and the state acts, particularly in this state, retain a discretion where if the claim's brought more than 12 months after the supposed discrimination occurred, it can be terminated by the President of the Australian Human Rights Commission or the Victorian Equal Opportunity Human Rights Commission. But it's not guaranteed to occur, and I think there's some recent decisions where claims have been brought a number of years after the alleged discrimination is said to have occurred, and they've been allowed to continue so long as they're filed in the courts within the appropriate time after the certificate's issued, which is 60 days, I think, for federal court matters. So the timing, if someone comes to you after the 21 days for general protections and you don't think they've got exceptional circumstances based on sections in the Act, then you need to consider what are your other avenues, and discrimination might be one. Speed is another issue. Unfair dismissal is going to happen quicker. You're going to get to the tribunal faster, and or a conciliation or conference faster. It's going to be determined faster. Discrimination proceedings or general protections proceedings, which involve the commissions first and then the courts after, invariably take longer, require more work, and are inherently more expensive. The other issue is with unfair dismissal, there's minimum employment periods. General protections or discrimination claims often, as you've heard, can extend to prospective employees, but you don't have to have been employed for any significant period of time. You can have access to those remedies even though you're a relative, your employment's in its infancy. And that's something to be considered as well, particularly if an employee has, say, less than 6 or 12 months employment, depending on the size of the employer.
I don't know whether, Angus, you've had this or not, but I think that also shocks some employers. Maybe one of the other panel members can speak about it, but to find out that a general protections application can be brought even by a probationary employee opens the eyes of some employers to be as big as saucers. Have you experienced that as well?
Well, certainly I've had been giving advice to people where they clearly didn't meet the minimum time employed, and it's you find in a lot of employment contracts, and this leads from what Tim's saying, definitely I think that probationary periods have tended to mirror the minimum employment periods in the Act rather than being really tailored to the type of position that the employee is in. Obviously, the more senior the employee, you can justify longer probationary periods. So in that sense, I think it has been a bit of a changing in the guard, and people are starting to catch up with it, as Tim suggested. But it's always something to look for, particularly even if I know we're getting off it a bit, but contracts and drafting those and appropriate probationary periods are all things to consider. There's also certain threshold issues with some claims, particularly unfair dismissal, award coverage, high income thresholds, enterprise agreements that don't apply in general protections and discrimination claims. So it may be that particularly high income employees that aren't covered by modern awards and things like that are able, or it's more appropriate for them, or they're only able to bring claims for discrimination, general protections or contractual related claims. Only employees can make unfair dismissal claims. In terms of general protections, as you've heard from the paper, there's more people that can make them, even though we're principally dealing with employment here, it can extend to contractors. And discrimination claims, well, there's some differences between, but essentially it's employees, contract workers, commission agents, and the definitions of employment in a lot of the pieces of legislation extend to contracts for services, which would pick up independent contractors. Obviously, how the applications are dealt with, which has been discussed, is another issue. Forum shopping is alive and well, but one thing that often I think can motivate or is something to be considered is that if you go through one of the commissions first, whether it's the Fair Work Commission or the Human Rights Commissions, if you choose that route, you often get 2 bites at the ADR cherry to try and settle the matter. And that can be incentive, particularly for applicants who are looking for deep pockets. There's no point denying it, it happens. and it's something that really deals into the costs of all these sorts of applications. Unfair dismissal claims are generally faster and cheaper. It can be very expensive for an employer, respondent and an applicant as well to run general protections claims. They start in the Commission, go to conciliations there, it's a preparation of documents for the Commission. It then obviously goes to the Federal Circuit Court or Federal Court, and like all litigation in those courts, it's time consuming, it's expensive in terms of interlocutory processes, directions, hearings, mediations, more formal methods of discovery and the like. It is certainly something, particularly in a jurisdiction that's principally no costs, it is something that is expensive financially and in terms of time, it's time. And so this was something that Tim and I discussed. That's something that I think forces the hand with some commercial settlements, and again, this idea of looking for deep pockets. The remedies, the issues of remedies have been discussed, but again, the reinstatement aspect is something to be considered, as Tim mentioned, but also the discrimination and general protections claims open themselves up to a broader range of orders, including injunctions and apologies, and there's very broad provisions in the legislation that give the relevant courts quite, again, broad powers to impose certain remedies. So often we have to reverse engineer these cases. You ask someone, well, what do you want? What's your ultimate goal? And then that can be a good way to work back to determine ultimately what type of claim you should not bring.
Angus, what about a potential employee if they bring an adverse action?
Yeah, but the prospective employees and employers is one of the people.
It's one of the categories, but it's one of the least explored, as you can imagine. I know of only 2 cases that have considered a prospective employee's application for relief, and I don't think either of them proceeded to awarding any relief to those prospective employees, because on the merits, the application was found not to warrant any relief. I think probably in those sort of circumstances, there's almost a practiced aspect to it. That is to say, the natural human reaction to something that's been run many times before is to give that more prospects of success. And in discrimination claims, there's a longer history of prospective employees having a right to relief. But I can't see that developing any great links in this area. It's simply a factual hurdle that's difficult to get over.
But the reverse onus would make it potentially difficult for the employer to...
I take issue with the expression reverse onus, even though everybody uses it and even though I use it too, because it really is just an evidentiary burden to be discharged. And in some circumstances, it's almost there's an invisible slew of cases out there where the employer couldn't discharge that burden and therefore the case didn't actually get on for hearing and doesn't result in a decision. And then there are a bunch of other decisions, and Barclay's been mentioned, that's one of them, where there was a cogent, thought-out explanation for conduct and that burden's been discharged. I know of one decision before Justice Tracy where His Honour said, I can't determine on the evidence who should win. And so by default, the onus kicked in, the reverse burden, and resulted in the applicant having what can only be described as nominal success. Now, as the respondent there, you feel a bit dudded, but at the same time, that's what Parliament intended. The Parliament intended for there to be a default position, and that's the default position.
Why is that nominal success? They win.
Because that's the way His Honour described it.
That was Tracy.
That was Dick Tracy, yeah.
One of the other ones, just touching on that, where what Tim was saying, and from Phil's question, is prospective employees and employers. The other one is, and I was just asking Jim about this, is an employee can take adverse action against their employer. I'm not aware personally of any cases. Tim may be. It's an interesting one. The adverse action includes ceasing work in the service of the employer.
Why would an employer sue for that kind of relief when industrial action relief under 418 exists under the same legislation, and presumably has even though it could be fairly described as a quicker and dirtier road to relief, certainly 418 allows you to get on very promptly. From memory, that section requires the tribunal to hear it within 48 hours of an application being instituted. I think, as you can hear from some of the panel members talking about it, the speed that attends an unfair dismissal really, and the cheapness and therefore the efficiency, doesn't really exist in general protections, and that makes it, for some applicants anyway, a very much a second best regime. There has been discussion from the current Workplace Relations Minister, consideration of whether general protections ought to be brought under the umbrella of the Fair Work Commission. As far as I know, that's only been a soundbite so far, and given the political background, Minister Shorten may not be Minister Shorten for all that much longer. But it seems to me that that's something to watch out for.
Now, there's been a number of elements as to the choice of tribunal or court. Underpinning a number of those choices is the question of causation, and I think Jim's got something to say that will take not very long in relation to the causal element in the cause in these respective causes of action.
I would very much like you all to ask my learned friend some questions, so I've committed to 30 seconds in answering this issue. Causation in these matters is exceptionally complicated, and one only has to read Purvis to realise that. I reckon I've read Purvis 30 times, and every time I read it, I come out thinking it means something different. In Barclay, the High Court have come along and said, it's not that complicated, it's just a factual question, why was the treatment as it was? But they have not rejected the test that underpins Purvis, Banovic. It's the search for the real reasons, a real test. It's not an objective test. It's not a subjective test. So anyone who tells you that if someone gets in the witness box and says, I did the reason because of X, and X is not a prohibited reason, that's the end of the story, it's not. It remains a very complex area, and Barclay, I don't believe, I don't believe Barclay goes anywhere near as far as a lot of practitioners or a lot of judicial officers believe that it does in swinging a pendulum back towards employers. 30 seconds?
That was a good 30 seconds. It may well be then that the choice of tribunal in terms of a dismissal is the Fair Work Commission rather than the court under an unfair dismissal. But what's the differences in the remedies? I think Angus has touched on that. There's a limit of 6 months compensation, I think, unless reinstatement is ordered.
The high watermark for unfair dismissals is still the decision of the full bench in Moore Paragon, where some injured employees were paid 2 years compensation because the dual appeals had dragged on for so long. And I'm not aware of a high watermark in general protections. Maybe one of the others up here can speak to that.
Justice Gray was talking about in excess of $1 million in NTEU, but then he ordered reinstatement. So it didn't see the light of day, but there is potential in general protections for significant compensation, but there's not much actual orders of significant compensation.
So that section 545 is the general powers of the court for remedy. What we haven't touched on, although Angus did a little bit, is all this legislation seems to have moved the focus away from the state tribunals. Equal opportunity legislation in the state now seems to be have fallen into sort of a backwater. I don't know what any of the panel think about that, or what's the experience of anyone else here?
I think that's exactly right. I think now with general protections claims and the way they've been interpreted quite broadly as it's been developing has certainly become a preferred jurisdiction in relation to discrimination type claims. You still see them, they're still around obviously. The Victorian claims, most of the claims that I see or advise in relation to tend to be federal claims under the Age Discrimination Act, Sex Discrimination Act, Disability Discrimination Act. So I certainly think the State Tribunal and perhaps the Australian Human Rights Commission are fighting for work in that regard a little bit, but it really depends on the type of act that the claim ultimately comes under. There's some attributes that are protected in various discrimination legislation that aren't covered in the Fair Work Act, and so often what determines whether you go to it, for example, in the Victorian Act, there's an attribute, it's employment activity, and that is something that is quite broad in its definition and is an area that I think is ripe for development. I'm not aware of too many cases in the employment area. There's a few in relation to goods and services and residential tenancies, I think. Activities, the cross-references in that sense, but there's not huge amounts of case law on it, but it could be an area, an attribute that is, if there's change in relation to complaints and inquiries in relation to employment becomes more restrictive in the Fair Work Act, it could be a way to make simple complaints or inquiries an attribute that can be protected under the state legislation.
And I don't know about the experience of others, but one of the other things that I've noticed is that there's an increasing tendency in employers to outsource the decision-making process. And one of the problems, so by that I mean that they will appoint an investigator, an external investigator, to look into allegations. The investigator will make a report, and the employer can then act on that report and say, well, I acted on that report because that's what the investigation concluded. I didn't sack him because he was Asian. I sacked him because the report said he was a bad worker. The investigator might be rampantly racist. Who's the decision maker in that process?
Well, according to the authorities, and one of the authorities was mentioned by Jim in his speech, it basically means everybody who has had a hand in that decision-making process. And one of the authorities on that that comes to my mind is the old Greater Dandenong City Council decision under 298K of the Workplace Relations Act. And those freedom of association decisions are still relevant for general protections. They share many common elements of prohibited action, and deciding who the decision maker is, whether you're on the applicant side or the respondent side, is a key part of the strategy of preparing a General Protections Act.
Very brief, the Greater Dandenong argument was run in both NTU and RMIT, and also in the Visi ANWU case. And I think in both those cases, the applicants thought that was the basis upon which they were going to get up. And it wasn't in either of those cases, so it was significant, but neither of the federal court judges really latched on to that rubber stamp sort of argument to say that, well, the decision maker was really the investigator, and the investigator was prejudiced, therefore the adverse action is because of a workplace right or a protected attribute. So it exists there, but I think those two cases really were opportunities for the court to develop that line of authority here, and they didn't.
Perhaps some explanation. Greater Dandenong City Council was a Jeff Kennett type case. It was where Greater Dandenong outsourced in breach of an award, and I think it was the ASU then sued for the consequences of freedom of association and at the same time for breach of an award. The later Senior Deputy President Lacey was counsel in that case and called some but not all of the council as decision makers. So in a sense the decision in Greater Dandenong City Council at first instance and later on appeal was determined not because of the substantive merits of the application but because not all the decision makers were called, and that's its common element with the NTU case from Justice Gray that Jim's referring to. And that's a thread that runs through both freedom of association and general protections cases.
All right, so if you can figure out who made the decision to do what, and then if you can figure out why they did it or whether the action was because they did a particular thing or believed a particular reason, you can then choose the tribunal or court that you can go to. Bear in mind, I think, can I summarise very quickly, there are a range of alternatives which an applicant can choose from. An applicant can choose, in some senses, in circumstances of dismissal, a quick, cheap and relatively easier option in unfair dismissals in the Commission and can get on fairly quickly. They can go to the Commission if the dismissal is related to a prohibited reason and can get on equally fairly quickly. Thereafter, some of these complicated questions need to be addressed. One of the problems in this area is that they need to be addressed within a pretty short period of time. Now, we're going to stop talking and see if any of you wish to ask anything or make any comment. Yes?
So I understand that where an employee has an entitlement under a workplace law or instrument, workplace instrument doesn't extend to an entitlement under a contract. So where you've got a situation where an employer has changed the hours of work of an employee under the contract, but they haven't contravened the NES or the Fair Work Act. We had a situation where an employee brought a claim under general protections for having to start an hour earlier. There was no other evidence to suggest that he was being discriminated against or anything like that. He brought it, the fact that the contract was changed, would that not?
All right, so as I understand your question, the employee was a party to a contract which made provision for the spread of hours of work. The employee was also bound by a modern award or enterprise agreement.
No, there was no applicable award.
No applicable award.
Yeah,
Yeah.
the employer required the employee to commence working hours.
Okay, so, and the variation in the spread of hours
Yeah.
was consistent with the National Employment Standards. It's a question whether or not any of these alternatives that have been talked about today would provide some remedy for a unilateral alteration to the contract, in particular spread of hours.
You guys want to go? I think you're riding the ragged edge of Barnett versus TIO. If you look at Jim's paper, I think at footnote 31 he refers to a citation of at page 5. Thank you. Barnett versus TIO. That's the case that Jim refers to as being authority for the proposition that a contract of employment is not a workplace law, and I agree with what he says about that. But the question is limited because of Barnett's terms to that particular employee who was a senior employee in an insurance office, and he claimed that the workplace right, or in the alternative, the workplace law, was the obligation he had to supervise other employees. And in the circumstances of that case, which was initially appealed and then the appeal was discontinued, so we don't really know what an appeal court might have said, it was found at first instance by, I think, Justice Jago that there was no workplace law upon which that employee could rely. I think that's right for challenge. I think that's right for change. There is nothing in the definition of workplace law which would exclude the contract. And given that your contract specified hours, that might be something that I would look at closely in relation to, both in relation to distinguish Barnett versus TIO and to see whether in the secondary materials for the legislation, the secondary materials for that definition, there was any consideration as to what might amount to a workplace law capturing the hours question you've described. But it's not that question, that decision whether it's in or it's out under the definition of workplace law is the main question that I would examine.
There's probably one other issue that arises. It's not a breach of the general protections provisions to alter someone's position to their prejudice. It must be adverse action taken because of a workplace right. So if that employee said, you can't change, you can't do this, and then because they made that complaint, then their position was changed, then you have the causal connection. But if it's just an alteration that exists, because if what motivated the employer was, well, we want you to work different hours, not because they made a complaint, not because they had a right, then I don't think it would fall within the fundamental framework.
Now, any other questions? Philip Gardner.
Can I just ask, the statutory contracts that are in the Act that wouldn't they be workplace instruments? And in the example given, those statutory contracts, so long as they deal with things in the NES or in a modern award, are able to be enforced as statutory contracts. Therefore, they'd be workplace instruments.
Yes, you're saying that the NES includes a statutory contract, and that,
There's a particular
yes,
class,
which extends beyond, you say, a different characterisation of a normal civil contract.
Yes.
And because it's created by statute is a...
Yeah.
Now, I don't know of any case about that, Philip,
No,
but I can
I'm looking forward
understand
to
the
you
reasoning.
I'm looking forward to you.
But certainly understand the logic about that.
Philip and Tim agree. This is a lovely moment.
Oh, well, it's the first time in about 16 years, but yeah.
All right, now we won't then have a extreme discursus on statutory contracts. Unless there are further questions, then yes, there are two. Yes.
I just want to ask a more general question, and this is more a principal question. In relation to the Fair Work Commission, or Fair Work Australia as it was called, a report was released that 95% of litigants are self-represented in Fair Work Australia. I don't know in relation to adverse actions. Does this mean that the behemoth that is the Fair Work Commission is really another VCAT and a case, and further, because it's a no-cost jurisdiction, does this limit the right of litigants to pursue actions? Should it not be a no-cost jurisdiction? What are your thoughts?
There are two questions. Effectively, the impact of litigants in person in the Fair Work Commission.
Yes.
In a practical sense, that's always been a problem.
Right.
Not a problem, but it has been a fact that has to be addressed. And as a way of addressing that question, the President has now established a sort of a duty solicitor panel for self-represented litigants in the Fair Work Commission. There may well be some significantly higher numbers of self-represented litigants because the Federal Court recently has criticised the Fair Work Commission for giving lawyers permission to appear far too easily. And so I think the Fair Work Commission is going to tighten up that. As to whether it all becomes something like VCAT, I don't know precisely what that means, but there is a filtering process. With unfair dismissals, there'll be the duty solicitor process, and then there's a telephone mediation that has a fairly high success rate, and even after that the intervention of commissioners can occur. So I think that's okay. The second question is a more fundamental philosophical question about whether or not there should be cost or no cost jurisdiction. Historically, the cost-free jurisdiction has been in place to enable access to the courts. That is, very few, particularly individuals who are enforcing individual rights, have money to litigate. And, it has been an ongoing question as to whether that should change. My own view is that it probably operates, that is, no cost, operates as a better avenue to allow people to get access to the courts than having a cost jurisdiction. And the Supreme Court of Appeal recently, in a completely unrelated jurisdiction, recently made orders, I think, in respect of a young person who wanted to sue the police, excusing him from being liable for costs. So I'd probably go back and read that decision in the context of this discussion. Now, there's one other question, and then we've got to pull the pin.
My question is, when the adverse action results in a fundamental change in the employment contract, how does that sit with the 21-day time limit?
When you say fundamental change...
Fundamental change resulting in effectively a new employment...
Well, it depends on whether... First, find your dismissal. If there's a dismissal, you're on a 21-day you have to file within 21 days, and I suppose that's also true for. I'll hand over to Tim to do a quick answer on this, and then we'll.
Yeah, sorry, what was the thinking?
The question was, I think, what is the position in terms of bringing an application, and where would you go effectively if there is a change to the contract for a prohibited reason, such
This,
that you,
yeah, that's
arguably whether the contract has been repudiated and whether it may not have been accepted,
yep.
and in circumstances where it may not have been repudiated or the repudiation not accepted.
That the question of repudiation of a contract for a prohibited reason would give a person a right both in the Federal Court or the Federal Circuit Court, and it would also give a right if the repudiation were acted upon for damages in the accrued jurisdiction of either of those places. But because if there were a termination involved, there would be the 21-day period that you'd have to go through the steps in the Fair Work Commission first before those two court application rights could be seized upon and utilised. Lots of recent law in New South Wales about repudiation. A couple of really significant injunctive relief cases, and one on the merits involving a stockbroking firm that acted to sue an individual employee who had repudiated by going to a competitor and had failed to serve out the fixed-term employment contract. So very simple and very long-established contract law in that case, and not incompatible with the statutory rights.
It's 21 days from when the dismissal took effect. So this is probably something that Tim can comment on better than I can, but repudiation, the employer may elect to accept that repudiation. That may be sometime after the actual repudiation. So it may not be 21 days from the date of repudiation, it might be 21 days from the date of acceptance.
The date of effect definitely is the date of effect.
All right. Well, I think that is all we've got time for this morning. Once again, thank you all for coming, and thank you to our panel, each of whom have put a bit of time and effort into their papers and discussions this morning. So I'd ask you to thank the panel in the normal way.